Well, thank you guys for coming here. And as Danielle mentioned, this is a webinar, so we won't be able to see you or hear you. So if you have a question, you can just submit it into the Q&A. It'll be either on the top or the bottom, depending on how your screen is formatted. And then we'll answer all the questions at the end. So in case you don't know who I am, I'm Stephanie McCuba, and I'm an estate planning attorney. And I will be presenting the first portion of this, which is focusing on trust and trusteeship. And there's a few reasons why we decided to put this webinar on. And the main one is oftentimes people kind of get overwhelmed when they think of estate planning and creating a trust. There's just so many little choices you have to select. So we wanted to hone in on one of those, and that's the trustee, and kind of break that down as a starting point for people. I'm particularly excited to be presenting with Danielle because she's a professional fiduciary, and I found a lot of my clients don't know the benefits of a fiduciary, and a lot of them don't even know professional fiduciaries exist. So I thought it was really a great opportunity to spotlight how a professional fiduciary could possibly benefit your estate planning depending on what you need. So I will be presenting first, and then I'm going to be presenting on the role of a trustee.
And I thought I would introduce you folks to Stephanie. Stephanie McCuba is an estate planning attorney. She opened her law offices in 2016. Before she opened those offices there, she was an estate planning attorney with another firm in Glendale. And there she focused exclusively on conservatorships, estate planning, and probate litigation. So this topic is perfect for her. Her favorite part of the job is helping clients with matters from start to finish and making complex legal procedures understandable. And that's one of the reasons why I wanted to partner with her, because she's very good at simplifying and keeping the topics understandable. And she's a very calm but perky personality, so I think she's great for this. So I hope you enjoy.
Thanks, Danielle. So before we dive into trusteeship, we need to kind of back our way out of that and think about a trustee being in charge of a trust. And so we have to know what a trust is, and then we have to know what a trust role in an estate plan is. So we'll start with the estate plan, and broadly what an estate plan does is a succession guide for your assets when you're gone. And then it also says who should be in charge of distributing those assets, or also being in charge of you if you become incapacitated. So the main documents that compose of that estate plan are going to be the revocable trust, pour over will, a power of attorney, advanced health care directive, HIPAA release, and then a deed or some other transfer assistance for your remaining documents like your bank accounts and your investment accounts. We're only going to be focusing on a trust today, and particularly one type of trust, and that's a revocable trust, or also commonly called a living trust. And what a living trust does is there's three reasons why most individuals create a living trust. And a living trust is kind of just like a contract with yourself saying, I'm putting my assets into this trust, and here's who's going to benefit from those when I'm incapacitated or gone. One main reason is probate avoidance. So we often hear that word probate avoidance, but a lot of times we don't break it down and think about what it actually means. And the probate court is a specific court that is assigned just to determine where the assets of deceased individuals should be going. And the court monitors that whole process. That's fine in the past. That's how most wills got administered. But the problem with it now is that the courts are so backlogged and underfunded that it's taking 1.5 years, 2 years to actually process an entire probate. So we want to avoid that just due to delays. And that's not even to mention now there's delays. The courts have been closed for about 2 months, and expected not to open till middle of June, if that. So we have an even larger backlog, and probates particularly are not going to be given any special priority in that, so the delays are going to be even bigger. The other thing about probate is the cost. They're It's pretty astronomical, the cost of probate. That's because the attorney's fees and executor fees are based on a percentage of the value of the estate. So for example, if you have a $500,000 estate, then probate fees for the attorney and the executor are about $26,000 paid at the end off the top before the beneficiaries receive their portion. And that's not even considering the thousands of dollars of court costs like the filing fees and the probate referee fees that you have to pay. So costs and huge delays and the onerous requirements of the court are the reason people want to avoid probate. And a trust does that for you. Second reason is incapacity protection. So in case you are incapacitated, you get in a car accident or you end up in the hospital, then someone can make your decisions for you. And the trustee has that role. Third reason is that the trust can create, we can create special trusts that protect various beneficiaries. So for example, we can create a special trust for minors to make sure that the assets are held for their benefit, or even put certain age requirements on it. So maybe you don't think someone should receive assets until they're 25 or 30, or you want to go really far. I've seen some people do 65, and you want to hold those assets until someone reaches that age. We can do that with a trust. Another kind of beneficiary is someone that might benefit from a special needs trust. So they're on SSI or Medi-Cal or some other government benefit program where that would be, those benefits would be taken away if they received a large amount of money through an inheritance. So then we just create a special needs trust for them, and they can keep their benefits but still receive a benefit from the amount of money that you left to them. Another reason is itemizing specific bequests. So you can say $10,000 to the charity of my choice, or wedding ring to my niece, sewing machine to this person. You can kind of all itemize that in a trust. And then the person that's going to be in charge of the whole trust is called the trustee. So that's the main event here, the trustee. What is the trustee? What do they do? And you can think of the trustee as like the manager of a trust. They're in charge of following all the rules that are outlaid in the trust, and then ultimately administering those for your benefit, the beneficiary's benefit, and then distributing those at the end. And then the trustee, so the trust's main purpose is to guide the trustee as well. So they're going to outline rules, like think of a trust as a rule book for a trustee. So they have to follow all those rules that you assign to them. And then they also are guided by certain fiduciary duties that are outlined in the probate code. And you can also think of the probate code as just the state's version of a rule book for the fiduciaries, the trustees. And so some things that the probate code outlines is the trustee has to administer the trust according to the terms, which we already talked about. They have to account to the beneficiary, so tell them what money's coming in, what's going out, what money they have left, what they paid themselves, those sort of things. Furnish information to the trustees, keep them apprised of the progress of the trust. Those are all the kind of rules that a trustee has to follow. And so then that really leads to a lot of people ask, well, how is that all enforced, since, you know, the point of this is to avoid going to the courts at all. And normally the court would be monitoring administration and kind of poking the trustee along to do the right thing. But here we have no court involvement. So who's enforcing this thing? And the answer is really the beneficiaries. It's on them to make sure they're getting the correct information from a trustee. And if something seems wrong, saying something about that. So because there's no court involvement, unless something goes wrong, we're hoping for no court involvement. It's really, you have to really think about naming a trustee that's going to do a good job and follow the rules, because no one's going to say they went out of the lines here or there or the other thing. It's only on the beneficiaries. So that's kind of how professional fiduciary is going to be pulled in, and we'll talk more about that later, but just something to keep in mind. Another common question about trustees is the difference between a trustee and an executor. You'll hear that those two terms used interchangeably, and they're really not interchangeable terms. So a trustee is just in charge of the trust, and all the assets you put in the trust, they're the manager of those assets. And their role becomes effective as soon as the document's signed, which then leads to the executor, who's in charge of a different document. The executor is in charge of the will. And the will is only going to be effective once you're gone, and it actually goes to the probate court and the executor is appointed. So they might never actually start to act if they never are appointed by the courts. So we want to think of executor in charge of will, trustee in charge of trust. If everything goes right in your estate plan that you create, the trustee is going to be the only one acting, because we don't want to go to the probate court where the will would be the executor. There's also a distinction between a trustee and an agent under the power of attorney. So trustee, like I said, in charge of trust, and then agent under the power of attorney is in charge of all non-trust assets during your lifetime. So you can think of this as you're alive but incapacitated maybe, and someone has to call Social Security Administration on your behalf. Someone has to call Verizon Wireless to cancel your contract. Those two things are related to you financially, but they have no tie to the trust. The trust name isn't on them anywhere, so we need the power of attorney to do that. So all three of these roles, trustee, executor, agent under power of attorney, they're just kind of like different hats someone has to put on in order to have authority to act on your behalf. So it can be the same person acting in all three roles. Don't think they have to necessarily be three different people. It just can sometimes be confusing which hat you're supposed to be wearing. So that's why it's important to understand all those roles. And so depending on what hat you're wearing, you might be acting at different times as the trustee or the settlor, successor trustee. There's all these kind of terms. So like I said, as soon as a trust is signed, someone has to be a manager of that trust. So there has to be a trustee right off the bat. And most of the time, that initial trustee is going to be the person that actually signed the trust. And the person that signs the trust and creates the trust is called a settlor, most commonly, also called trustor, grantor, trust maker. It just depends on how the trust actually defines that person, but just know that's the same person. So like I said, most times you're going to create your trust and you're going to appoint yourself as the manager, because why not? You don't want your life to significantly change. You don't want someone else to be doing your bidding for you if you have capacity. There are certain circumstances where someone's going to name someone else as the trustee, or even a co-trustee. So this happens a lot of times if someone gets around to signing their trust when they're in their late 80s, early 90s, they're losing their hearing, they can't drive anymore, so they just need help with things. They have full capacity, but they just need a little bit of assistance. And maybe right when they sign the document, they'll name a fiduciary or their oldest child as the co-trustee to start acting with them. But for most people that are creating the trust as a way to avoid probate and get assets to the beneficiaries, they're really going to start off as the trustee. When that might change again is when they become incapacitated or if they resign. So if the settlor, the creator of the trust, becomes incapacitated, then the next in line that they wrote up is going to start acting as trustee, and they're going to kind of be acting in a management role, making sure bills are paid, selling the property if someone needs to go to a skilled nursing facility, and that's determined to be the most appropriate course, but pretty much managing all those assets for the creator of the trust, because at that point, the creator of the trust is still the beneficiary. They still owe the duty to that beneficiary to act on their behalf. A trustee can also resign. So same thing, like I said, if someone wants to appoint a co-trustee to start, sometimes people just, don't want to have the job anymore. So they want someone else to manage their affairs, and they can resign and appoint a new trustee. That's totally fine. Also, the big change of trustee is when the creator of the trust passes away. And then that new trustee that steps in is going to have more of an administrative role. So they're going to check the terms of the trust, see where the assets are going, see if there's any sub-trust that we need to fund, work with the beneficiaries to get all of their information, prepare tax returns, reports to the beneficiaries, sell the property, and ultimately wrap everything up. So it's a lot of work to be a trustee, and maybe some people don't know what they're getting themselves into. So you should be educated on what your trustee actually is going to have to do. That's why we can kind of go through some qualifications and considerations to make sure you do choose the most appropriate beneficiary. So the basic qualifications is someone has to be over 18. That's easy. They should ideally be a U.S. citizen so that there's not a foreign trust trigger for the IRS, where then you have to report a bunch of things you don't want to get into. So ideally, then it's a U.S. citizen. They should be financially savvy, at least moderately so. Can they open up a bank account? Do they understand basic principles of managing someone else's money? Can they ask for help when they need it? So can they reach out to a CPA? Do they know how to find a good CPA? You'd be surprised people don't know that. So just make sure your person you're appointing is capable of doing that kind of thing. They also should be able to act independently and fairly, because remember, their job is to act in the beneficiary's best interest in accordance with the terms of the trust itself. So if they're going to pick out one beneficiary to favor over another or manipulate the administration to their benefit, you don't want to appoint them as your trustee, because remember, the court's not supervising them. And then a common misconception is that the trustee cannot be a beneficiary. That's not true. You can have your 3 kids as the beneficiary and name the oldest child as the trustee, so long as they fit the bill and they're qualified to do so. So besides just basic qualifications, or should someone be a trustee, some other considerations you want to take into account are time restraints. Does this person have enough time to actually administer the trust? We went through all of the roles that someone's going to have the duties, and they're probably going to have to take off work if they have a job to get a lot of this done. So do they have the ability to even do that? Or are they running around with kids and an 80-hour work week? Also, the physical location of the trustee might be important. So if they're across the country and there's significant admin work to do here in California, are they going to be able to take the time to keep flying back and forth for week-long trips to wrap things up? You'll want to think about that. And then, do they have the expertise required for trust administration? So like I said, at some point, some of these trusts might continue on because we might be creating these sub-trusts for the beneficiary's best interest, like a special needs trust. And if someone doesn't know how to administer a special needs trust and they don't ask for help, they might have a huge negative consequence on that beneficiary when their benefits are taken away. And we really don't want that to happen, because then the trustee also gets in trouble and the beneficiary loses their benefits. A big one is expected beneficiary conflict. So you can probably imagine how many parents pass away and then all these weird sibling rivalries come out of the woodwork, and just make the whole process a nightmare for whoever is the trustee at that time. So if there's already underlying rivalries between beneficiaries, you should really take that into consideration when choosing a trustee. And so those kind of considerations often lead someone to think about appointing an independent individual. And that's where the professional fiduciary can really make a difference. And I found a lot of people don't know professional fiduciaries even exist. So then I'm going to introduce Danielle, who will be speaking next on kind of how the fiduciary can fill that gap within your estate plan if you really don't have anyone that fits the bill to be your trustee. So Danielle founded Integrity Probate and Trust Services in Laguna Hills, California, after successful leadership roles in insurance, healthcare, and other industries. She sees her role as a fiduciary as a calling with a nurturing bond of trust and concern. She strives to support well-being, reduce the stress of changing circumstances, and help clients and families enjoy a fulfilling life. Danielle earned her MBA at the Drucker Graduate Management Center, and she's a member of the Orange County Bar Association and the Professional Fiduciary Association of California. So take it away, Danielle.
Thank you, everybody, for attending today. Again, I will be talking about the role of a professional fiduciary. There aren't a lot of us out there, and a lot of people, even if they know one, don't know what we do. So I appreciate Stephanie for inviting me and allowing me to help some of you folks understand what a fiduciary is and does. In general, as Stephanie mentioned, as a trustee, when people are developing their trust, when they choose a trustee, typically they'll start off naming themselves. However, they whether it be as a trustee or a successor trustee, some of the other options include a friend or a family member, a corporate trustee, such as a bank. When you think about a bank, most people think that they can just go to any bank. Well, not all banks offer this service, and even if they do, many banks have a minimum, such as perhaps $1 million trust. So if your trust doesn't have a lot of assets, a bank may not necessarily be an option for you. And additionally, for better or worse, a bank tends to be a lot more institutional. So that can impact the nature of the relationship as well. Another option is a professional trustee, such as myself. So we again offer a different type of relationship, and some of the things that we do might actually be broader and a little bit more unique than a corporate trustee. So let's see. So what is a fiduciary? A legal definition, a legal meaning, is to put another needs before your own. For example, as a fiduciary, if I have full rights, full realm within the trust, I might be able to spend as much time or as little time administering that trust. But my responsibility is to make sure that I put the trust and the beneficiary's needs above my own. In other words, I'm not maxing out the hours so that I make the most money. I'm doing the work that's in the best interest of the trust. And that applies whether it be my role as a trustee or my role in other activities such as conservatorships and things that I will allude to later. So again, putting another's need first is a primary responsibility of a fiduciary. That's a legal meaning for it. Now, a fiduciary we're typically named in a private contract, such as a trust, or we might be nominated by a court to assume a position of trust. A fiduciary, by definition, handles somebody else's affairs while they're still alive, or after they've passed away. So in essence, what I do, I support and advocate my clients' estate planning, financial, and healthcare wishes during and after their passing. California professional fiduciary. I'm getting drilling down a little deeper. In California, professional fiduciaries are regulated by the state. That doesn't necessarily apply in all states, but in California, we are regulated. In California, we have to pass 2 exams, a state exam and a federal exam. So as you may have noticed in the alphabet soup after my name, I'm a California professional fiduciary. I'm also a national certified guardian. So I have to pass these exams, and I also have to earn continuing education. I'm required to follow the probate code and to answer to the court, even in situations where the case isn't court modified, court overseen. I may still have to answer to the court. Now, a professional fiduciary, we can be bonded additionally to protect beneficiaries and heirs if that's something that the trustee in this case chooses to do. So some common fiduciary cases. If somebody doesn't have a family, or they're not close to their family geographically, or there's too many issues with the children. I've got a number of cases like that that the parents have chosen to hire me as a trustee and a power of attorney because either they don't have children, they can't count on their children, they don't want to put the burden on their children. Another option is a trustee that's become incapacitated, whether it's the original trustee or a successor trustee, so that's one situation. Another one that's common for fiduciaries is if a trustee or an executor passes away without succession. So that's again where it makes sense when you develop your trust to name not only yourself as the initial trustee, but also name a successor trustee. If you have not named a successor trustee, then somebody such as a professional fiduciary may be nominated by the family or the courts. If there's a situation where the trustee mismanages the trust or neglects their duties, again, another case that I am, one of my clients is the daughter that was supposed to be trustee, essentially was found to not only not be managing the assets, but also she was also supposed to be taking care of her mother, and she was also neglecting her mother. So in this case, the court has stepped in and named me as a temporary trustee and a temporary conservator. Another situation that is good for fiduciaries, that makes sense for fiduciaries and why we are here, is when there's contention amongst the beneficiaries. So if the beneficiaries are fighting, and this is very, very common, it's really sad. It's very sad, but it's very common. So if it makes sense to bring in a neutral third party, then quite often it's something that's brought to us as well. Another situation is a special needs trust. And Stephanie mentioned this. So if in another case that I'm involved with, the parents have a daughter who has a medical condition, and she's been protected most of her life. She's physically incapacitated, but mentally she's okay, but she's just a little bit naive, shall we say, maybe isn't capable of making the appropriate decisions for herself. So in this case, they would name a fiduciary as a trustee to ensure that the beneficiary continues to receive their benefits. If a special needs trust isn't managed appropriately, it's set up to provide, to ensure that the beneficiary receives benefits, public benefits, and the special needs trust supplements that with additional needs. And if that's not managed appropriately, then the person could lose their public benefits and could really impact their financial situation long term. So why would somebody consider a private professional fiduciary? Again, it makes sense to bring in a fiduciary as a neutral third party, and we're held to very high standards, higher than a family member would, because of our training and our licensing. You may also want to consider a private fiduciary because we relieve the family and the friends of the caregiving and the administrative task, so that friends and family can maintain those relationships amongst themselves as well as with the person. We also offer objective legal and financial expertise while we're managing the affairs. We work closely with a multitude of providers, as well as attorneys and CPAs and many different advisors. So we do offer that insight, and this is something that we do professionally. So some common fiduciary roles some things that we would typically do might be daily bill paying, money management, healthcare representation. If somebody needs to go to the doctor, sometimes it makes sense to have another set of eyes and ears there, listening to what the providers are saying, maybe coordinating if it's a complicated case, coordinating some of the different providers and services to ensure that the timeliness and transportation's there, and a number of different things. Insurance management, making sure that claims are paid and the benefits are getting received. And as we're talking about here, a fiduciary would typically serve as a trustee or successor trustee, an executor or administrator of an estate, an agent under a power of attorney, making sure that, again, some of the things that Stephanie was saying, making sure that your Verizon bill is taken care of and those kinds of things. And then I mentioned conservatorship, and that's beyond the scope of this presentation, but that's also something that you could bring in a fiduciary for. So some qualities to look for in a fiduciary. Something that's willingness is important. Is it a case that that this fiduciary would want to do, that and that the individual that you're bringing in has the time and the resources and the ability to do it. Competency, as Stephanie mentioned as well. Objectivity. That's another part of what we do. We can't be biased. We act in the role of our focusing on, we have a duty to our client, but again, if there's multiple beneficiaries, we can't play favorites. Financial experience, discretion. We have to honor the rights and wishes of the trustee, as well as keep things confidential and only distribute and disseminate information and documents as necessary. Patience, because these situations can be challenging. Attention to detail, the devil's in the details. Conflict resolution, when there is infighting in the family, it's our job to manage those as it applies to the case. And interpersonal skills, to work with everybody, work with all the various providers, and in addition to working with the courts and the other attorneys. And open communication. If you aren't hearing from the trustee on a case, that could be a challenge. They need to be communicating with the beneficiaries and with the partners. I commonly get asked about fiduciary fees. So the fiduciary fees do vary widely based on geography. They'll vary from state to state. They'll vary even from county to county. They're also impacted by the complexity of the case and the types of services that are needed. Is it a really simple trust? Are there a lot of assets and a lot of sub-trusts? And what are the types of services that are needed here? Now, fiduciary fees can be a percent of the value of the trust, or they can be an hourly fee. It depends. These things, again, they vary widely depending on needs. Now, if a case is court supervised, then the court has to approve the fiduciary fees. And the fiduciary fees are typically paid out of the estate or the trust. So I believe that we probably have some questions. If you have some questions, feel free to enter them into the Q&A, and perhaps we have some that have already been typed in. We look forward to helping you with those. And Stephanie, did you have some queued up?
Yeah, so the first question was about bankruptcy in a trust, or kind of alluded to that. And that's actually a common question. Not only just bankruptcy, but a lot of people, when they're looking into a trust, they often have questions about creditor protection. So say after they create a trust, if they go and get in a car accident with someone, then, is their house going to be protected from that creditor coming after their assets? And no, for the trust that I was talking about today, your revocable trust, that does not offer any creditor protection largely during your lifetime. The reason for that being is it's still tied to your social security number, and you're the beneficiary and you retain control over that. So for those reasons, a creditor can still seek those assets. that's why maybe if you have a business or something that has potential to have creditor issues, you want to make sure that's wrapped up in an LLC or a corporation where it does offer creditor protection. And then another question is for you, Danielle. And so why do some people choose corporate trustees over professional fiduciaries?
The benefit of a corporate trustee that many people perceive, real or not, is the one benefit is the succession. When you have an institution, you have a built-in succession that organization, especially if it's a bank that's been around for decades or even a century. You've got an organization that will and should be there for you at time of need. So that is one benefit of a corporate trustee. There's also, depending on the nature of the organization, there's a lot of built-in resources and partnerships. As a professional fiduciary, I will say that we do have those same solutions in a different manner. The fiduciary world, as I mentioned, it is a very small group of us, and we communicate daily. We are in partnerships daily, and we do reach out to each other for cases and saying that we need somebody who speaks a certain language, or we need there's need for a trustee in a certain geography, or different types of things. So the fiduciaries, that's how we handle succession, whether it be documented, and there are we typically will have partnerships and work together on cases. So that's one way that we answer it, and we can help to nominate another successor trustee in those circumstances. And then the partnerships, again, as through both Stephanie and many of the people who are on this call today, I partner with many of you, and I bring in many of you on cases. So when it comes to other resources, that's a part of our job to make sure that we've got the partnerships and the skills and expertise that are needed to be brought into a case.
Thanks. So then another question is about what happens to the home if someone dies and the estate goes to probate? And then does the beneficiary have to continue making mortgage payments? Can they sell the home? So if someone does not have a trust, then that's why we're in the probate court to begin with. So they either had just a will or they didn't do any planning. And then now the only way to get that trust, to get the house to the beneficiaries, is to go to the probate court. And so if there's a mortgage on the home, if there's two types of mortgages largely that we're dealing with when people pass away. One is a reverse mortgage, and the other is a standard mortgage that you take out. The reverse mortgage has certain parameters through that, and if you're familiar with a reverse mortgage, then you know it's someone that's 55 or 65, older, let's say, that's able to take out a reverse mortgage. At 62, thank you for the answer. So that has more of a time restraint on it than a standard mortgage. Standard mortgage, certain individuals can automatically take over the mortgage and start making payments. Like a spouse, there's no problem. Spouse can just take over the mortgage, even if they didn't initially qualify. Same thing with children. But if something goes to the probate court, then the property might have to be sold. So there's a lot to be done in the probate court, and it just depends on a whole parameter of what happens. But most situations, the beneficiaries want to sell the home because they don't want to own a home together. Usually it's a bunch of kids, and often they don't want to own it together. So the property will be sold.
Now, one thing I want to mention here as well, we were going to try to end around 12:45. We do have a number of questions here, so there might be some that we might not be able to get to, but you will have the opportunity after the workshop. We will be sending out an email. So if you'd like to request an appointment with one or both of us, we can schedule some one-on-one time to address your specific issues. Did you see some other questions, Stephanie? That makes sense? that we can
Yeah,
address
there's
briefly?
another question. I think we'll do, yeah, we're almost out of time, so we'll do a few more. Whether co-trustees can act together, or if two trustees can even act together. And then I think you can answer that about whether you act with a co-trustee. So yes, off the bat, we can have co-trustees as the next in line for you. Say you've got two kids acting together and they get along fine. That's wonderful. The only issue is if those two people you appoint together don't get along, then we run into real issues. So a lot of people are tempted to, married couples particularly, they want to kind of we can't decide, so let's just pick your brother and my sister. We're going to throw them together and see what happens. Hopefully they'll, quote, work it out. That doesn't happen. So if they don't know each other and don't have a good relationship, you don't want a death in the family to be what brings them together to try to administer something. It's not advisable. So if you do go the route of co-trustees, then make sure they really are able to get along, because there's a number of situations where it is beneficial because they can act either or can act. So one person can write a check for this, another person can access this account, do that. So it makes things easier, but just keep that in mind. And then Danielle, do you ever act with non-fiduciary co-trustees?
Generally, it's ill-advised for a number of reasons. A big reason is that because of our licensing, we are held to a certain standard, and we have tremendous liability in the work that we do. And if we bring on a co-trustee who doesn't have the same background, training, expertise, and liability, we are held to that same liability. So we run a risk if we work with a non-licensed co-trustee. So that's typically not something that we do.
Okay, great. So we've got time for one more trust question. So the next question was about whether non-fiduciary trustees can receive payment as well. So say you nominate your son as your successor trustee. Yes, so long as that is in the terms of the trust, and there's not something to the contrary. So some people write trusts that say any successor trustee is to not receive payment compensation for their services, because some people see it as a moral obligation for their child to serve in this role. In that case, no, they couldn't get paid. And Danny, a professional fiduciary would not be acting in that circumstance either, unless they were nice and doing some pro bono work or something. But largely, we have to look at the terms of the trust. And if the terms authorize like reasonable compensation, then we just look at what generally in that county, what in that area, kind of like what Danielle already went over, and base a payment on that. Okay, so we have a number of questions, and I'm going to save those, and we'll reach out to you individually if you ask the question, and kind of make sure that gets answered for you. And then if you have any other questions, feel free to reach out to Danielle or I, or both, and we will be happy to answer any questions that you guys have. So thanks a lot for attending our webinar, and we hope you found it beneficial, and at least you maybe took home a few nuggets of information that you didn't already know.
Thank you very much. Have a great day.